called to jury duty, it can happen to anyone. And if you get called to be a juror, there are some things that you want to know. Here to tell us more about the jury system is Colorado's best attorney, Phil Harding. Phil, thanks for coming in.
My pleasure.
Saw you hitting some balls a
Yeah,
little while ago.
well,
Sounds good.
I'm going to join the Rockies after this.
It's the opening day.
Yeah, I should be out there. Call me out.
Well, let's remind everybody at home why you are Colorado's best legal expert.
Okay.
For the last 6 years, you've been elected the top 100 trial lawyer in Colorado, a super lawyer again this year, and named one of the top lawyers in Colorado. Also, Newsweek, they call on you for some big cases, too, to get some experience and some tips and everything. So tell us what we're learning today.
All right. Well, let me tell you what we're going to go over. We're going to go over the jury system. Now, we have the distinct pleasure in this country of having our peers decide who's right and who's wrong. So this week, I want to go over this information and how to use it for your advantage, either to win a case or to be a better juror if you're ever called to be a juror. Let's start off with, and just kind of shoot right through this, the part what people don't know about and what jurors don't know. For example, if there's a trial and you're a member of the jury, more than likely than not, the parties have tried to settle this case before filing a lawsuit. Then from the time that they filed the lawsuit until trial, the court may have ordered them to go through and have another settlement conference. Next, if you see the defendant has an attorney, then more likely than not, there's insurance involved. But if anyone mentions the word insurance during trial, it's a mistrial. Now, here's another thing. The bigger the defense firm and the higher number of expert witnesses that are out there will usually indicate larger amount of insurance coverage. Here's another thing that you should know about. The judge may have already had hearings about excluding evidence and what people don't want you to know. And one of the things that you may hear about exclusion is the defendant may say, we've accepted liability. And this means that they say we're at fault, but the only thing that you have to decide is how much the plaintiff has been injured. Now, this is also code word for that the defense doesn't want you to know how all of this took place and how the accident took place, because the guy was either drunk, speeding, doing some crime. So that's excluded out.
So why don't we get to know how the accident took place?
Well, let me just take you kind of through an example here. If you found out that the accident occurred and the guy who caused it was drunk, you would give the plaintiff more money, wouldn't you?
I mean, I guess, yeah, it makes sense. You know that he's guilty.
Right. And you would have some sort of prejudice towards him. And look, here's the thing. The whole court system tries to remove these prejudices. If you found out that there was insurance, you may give him more money. So what we're trying to do here is create a crucible where you burn off the impurities. And that's what jurors do. They burn off these impurities, and they're only supposed to look at certain things. Now, another thing is I want you to look, we have a jury instruction. If you become a juror, you're not thrown to the wolves. But you have these jury instructions, and usually there are about 30 or so jury instructions that the members of the jury look at. And one of them, when they're deliberating, here's one of them that specifically says you will not be influenced by sympathy, bias, or prejudice. Now, our court systems have determined that if you know about insurance, you may give more money. If you knew the plaintiff was drunk, you may have a prejudice against him. And also, if there's any settlement negotiations, that's totally inadmissible as well. So if you knew that they tried to settle this case for $50,000 before, you as a juror may say, I'm going to give $50,000. So that's just kind of why things are excluded and why you have these jury instructions.
All right, so, if I was a juror, I feel like I'd want to know this information. Like if I'm sitting there in the courtroom, and I feel like I would need to know, be able to make a decision.
Yeah, I agree with what you're saying here, but here's another thing that I want you to know. When you get the collective being of a jury together, they don't miss anything. They recreate things that have been excluded, like the fact that there's insurance or the fact that the driver was drunk when he got in this accident. But you want to know what else the jurors don't know that always when I interview them afterwards, they get really mad about. And these are caps on damages.
All right, so what else do the jurors not know about?
And this is the caps, these caps by law. And look, the one thing that really makes them mad is Colorado laws have said that no matter how much you're injured and no matter how much a jury awards, there's an automatic reduction, and there are these caps, and we have a video here, or we have a graphic here, and let's talk about these. And what the caps say is, let's say someone has been injured and they have a brain injury. No matter how much they've been injured, the most that they can get, and if the jury awards $10 million, the most they can get in pain and suffering is $468,010. Now, you can still award money in past, present, and future medical bills, disfigurement, and stuff like that, and there are no caps on that. But pain and suffering, no matter what you as juries award, it's only $468,000. I got to tell you, I had this one case once where I had to prove beyond almost a reasonable doubt that a liquor store supplied alcohol and it killed 2 kids. The jury gave $1.5 million to the parents, but because of these caps, each parent, after the jury left, they thought they did the right thing at $1.5 million. They got about $200,000.
Why is that?
Well, that's these caps, and I got to tell you, I don't agree with the caps. But if you want to know what to award on the closing arguments, listen to the person the attorney that is representing the plaintiff.
Sure.
And what you do is when you listen to him, he'll say, look, only give $500,000 for pain and suffering. Now, you can give them disfigurement and all that kind of stuff, and that's unlimited. But on pain and suffering, there's a cap on that. So listen to that attorney, listen to the closing arguments, and that's what's going to guide you.
And listen to you, Phil. Thank you so much. As always, great advice. So you're helping Colorado out every single time you come on. And if you have a question for Phil, you can go to kwgn.com, click on Colorado's Best, and you'll see Phil's photo on the right. Just click there and send in your questions. He answers each one personally. And if you would like to contact Phil at his office, Harding & Associates, call this number. Write this down right now, 303-762-9500. You can get a free consultation anytime, and you can find him online at hlaw.org. And coming up on Colorado's Best, the truth about whole grains, how to make them a healthy part of your diet.